The last one in free concern is if the concern is not free but is caused by mistake. Section 20 defines an incorrect idea or opinion about something. It says erroneous about something. Mistake or error committed toward understanding the subject matter or towards identity of the parties or validity of the parties or toward the material attached to the subject matter, towards the existing of the subject matter. It are the erroneous committed towards the essential requirements of a contract. If this type of errors have been committed, then it is said to be void. It is not voidable, it is not valid, it is totally avoided, it is void. And mistake is of two types. Mistake as per law and mistake of fact, and mistake of law is further divided into mistake of Indian law and mistake of foreign law, and mistake of fact is further divided into bilateral mistake or unilateral mistake. Mistake of law, it's of again divided into two types, that is mistake of Indian law and mistake of foreign law. When I say mistake of foreign law, as a citizen of India while living in India, I may not aware of the laws of foreign country. An agreement made by parties in India making a mistake of a certain foreign laws. Of course, we are not familiar with that. It may happen. So, we should be familiar, but many of the cases may not aware of it. So, in that cases, when you commit a mistake, then it is void. For example, X agrees to import certain goods from China and sell the same to Y without knowing that China imposes restrictions on certain exported goods, on those exported goods. So what happens? The agreement between X and Y is void. It can't be enforced. Mistake of law is also, foreign law is also treated as a mistake of fact. Say, for example, I just start with an example. Throwing a waste material or spitting in a public places is an offense not punishable in India, but is offense punishable in that is your USA, Singapore, abroad, or foreign countries. What is related to mistake of fact is, but as an Indian visiting a foreign country has to be familiar with the laws of that country. If he fails to comply with it by mistake, then he will be liable for the legal actions as per the law prevailing in such foreign countries. On the other hand, mistake of Indian law says that every citizen of India is expected to be familiar with the law of India. He can't say ignorance of law. He can't say I don't know. Ignorance of law is of no excuse. A party to a contract cannot get in relief on the ground that he has something in ignorance of making a mistake of the law of the land. Therefore, the contract is not voidable. Actually, it cannot be avoided. Then he has to be punished for that act. And you can give one more example. An illiterate as a taxable income, he earns a taxable income, but he failed to comply with the provision of Income Tax Act, and he liable for the legal action under the act. It can't be avoided. It is also not voidable. He can't get enforceability. So he has to be punished for that act. When I see mistake as to the fact, it is of two types, bilateral mistake and unilateral mistake. Bilateral mistake, it means that both the parties to an agreement are under a mistake. According to section 20 of Indian Contract Act 1872, where both the parties to an agreement are under mistake as to matter of fact essential to the agreement, the agreement is void. And bilateral mistake may relate to subject matter of the contract or the possibility of performing the contract. When I say bilateral mistake as to the subject matter, it can be related to very existence of subject matter or to the identity of subject matter, or mistake as to the quantity of subject matter, and mistake as to the price of subject matter. We will take one by one. Mistake as to the very existing of subject matter. It means that From the beginning it is invalid, but a party may not have knowledge about it. So for example, suppose A agrees to buy B's dog of a certain sum, but the dog dies a few hours before the party enter into an agreement. So both the parties are not aware of it. The agreement is void. So startingly they are not aware of it. So it's told us error committed by the parties based on the subject matter. Next one, a mistake based on the identity of subject matter. Take identity. I have given all long back an example in your first class that I have two flats, I am selling one flat, I am not communicating properly which flat so it is related to the identity of subject matter. You can take some other example also. Suppose A, who owns two bicycles, such as you take Hercules or BSA, offered to sell his BSA cycle to B, and B thinks that the offer is for the Hercules cycle. There is a bilateral mistake and absence of constants and item. You remember while taking constants and item, I have given this example. So meeting of minds in the same sense, it is not there. So they are committing a mistake regarding to identity of subject matter. Error has been committed by both the parties. I am taking bilateral mistake where both the parties are committed the mistake. The next one, mistake as to the quantity of subject matter. You can take an example here. A stationery store receives an order of the supply of the gift pens packed in boxes numbering 200. It sends 200 boxes each containing 2 pens, whereas the customer's requirement is 200 pens each put in a box. There is a bilateral mistake as to the quantity of subject matter. See, he is asking 200 boxes which contains each box is 200 pens, but he is, because of his mistaken that, and he is sending that 200 pens. So that is totally related to the committed mistake related to the quantity of the subject matter. The next one related to the price of the subject matter. Price of the subject matter, I'll give an example. C, who wanted to sell a certain property to B for rupees 2,250 pounds and quoted 1,250 pounds by mistake in his written offer. C in fact had declined earlier an offer from B for the same property for 2,000 pounds. B too was aware of it but wanted to enforce C's promise. It was held that B was aware that the offer made by C was by mistake, so he could not enforce the promise. The next one, I left one point, and this is mistake as to the title of the subject matter. They have committed a mistake in this title itself. So for example, the leasee, the person who takes a property in the rent, the leasee, while executing the lease for conveying the fishing rights on certain ponds belonging to his land, included by mistake the pond located in his own land, then it is void. They committed a mistake in subject matter. The next one, we'll see legality of impossibility, where there is no possibility of performance. For example, X son Y without any authority from X receives 1/4 of the amount due by Z to X and releases him from the debt, and Y and Z think that the transaction is legally valid, but the transaction actually is void due to the legal impossibility. Next we have physical impossibility, and for example, ticket have been sold and purchased for the show by film stars without knowing that preparation given for the show by the local authority has been cancelled already. Next we will see unilateral mistake. Unilateral mistake says where one of the parties to a contract is under a mistake as to matter of fact. And then according to section 20T, you have a definition for this also. A contract is not voidable merely because it was caused by any one of the parties to it being under mistake as to matter of fact. We'll take an example. Suppose A buys a wristwatch from B. Thinks that it is worth of rupees 1000. The watch actually worth was only rupees 100. So A cannot avoid the contract. You can take one more example. A contract therefore cannot be avoided on the ground that one of the parties to it is under the mistake to as to the matter of the fact. So they should have the knowledge about what is their agreement is all about. So if I am going and buying a laptop for second hand and it has been more than for 4 years it has been in usage. So he is telling me for 10,000, but I feel instead of 10,000 it should be 5,000. So you're getting it for 10,000. It is a by unilateral mistake committed on your side. So before buying it, you should have the knowledge of what is the actual price of the product which you're going to buy. So thank you, students.